So, hello and thank you to everyone for joining us today. My name is Kristen McMahon, and I have the privilege of serving as the president of the Robert H. Jackson Center in Jamestown, New York. Today, we are looking forward to bringing you this conversation on the arrest warrants issued against Israeli and Hamas leaders by the International Criminal Court. And so now it is my pleasure to welcome our guests for this discussion, Ambassador David J. Scheffer and Professor Jennifer Trahan. Ambassador Scheffer was the first U.S. ambassador at large for war crimes issues from 1997 to 2001, and he led the U.S. delegation to the United Nations talks establishing the International Criminal Court. He negotiated the creation of 5 war crimes tribunals and chaired the Atrocities Prevention Interagency Working Group. He also served on the Deputies Committee of the National Security Council and as senior advisor and counsel to Dr. Madeleine Albright, the U.S. Permanent Representative to the United Nations from 1993 to 1996. From 2012 to 2018, he was the United Nations Secretary General's special expert on UN assistance to the Khmer Rouge trials. And from 2006 through 2020, he was the Mayer Brown Robert A. Hellman Professor of Law at Northwestern University Pritzker School of Law and is Director Emeritus of the Center for International Human Rights there. Ambassador Scheffer joined the School of Politics and Global Studies at Arizona State University in 2021, and he is a senior fellow of the Council on Foreign Relations. Jennifer Trahan is a clinical professor at NYU's Center for Global Affairs and director of their concentration in international law and human rights. She is an internationally renowned expert on issues of international law and international justice. She is also a prolific scholar, having published 2 digests on the case law of the ad hoc tribunals, as well as scores of law review articles and book chapters, including on the International Criminal Court's crime of aggression. She serves as one of the U.S. representatives to the Use of Force Committee of the International Law Association and holds various positions with the American branch of the International Law Association. She has served as an amicus curiae to the International Criminal Court on the appeal of the situation regarding Afghanistan and on the Council of Advisors on the application of the Rome Statute to cyber warfare. She additionally serves as convener of the Global Institute for the Prevention of Aggression and serves as special advisor to states and others on the creation of a special tribunal on the crime of aggression for the situation in Ukraine. Jennifer and David, thank you very much for joining me for this conversation today.
My pleasure.
Glad to be here.
So I always like to lay a foundation because our audience comes from a variety of backgrounds and experiences with these issues. And so I thought it would be helpful to start with an explanation of the International Criminal Court and how it operates. And David, I thought I would start with you with that question.
Well, the International Criminal Court has been operational since 2002. It currently has 124 nations as states parties to it, for the purpose of investigating and prosecuting individuals, not governments, but individuals who are charged with genocide, crimes against humanity, war crimes, or the crime of aggression. And the court was negotiated during the 1990s. It was started with the Rome Statute in 1998, in July of 1998. The UN was very involved in establishing all of the meetings for this. Their staff and council were very involved. And then it took actually a shorter period of time than I think many of us thought for it to actually become operational with 60 ratifications in 2002. But since then, it's the litigation before the International Criminal Court, which is based in The Hague and does not include some of the major powers. The United States is not party to it, Russia is not party, nor China, nor Indonesia, nor India, nor Pakistan, nor most of the Middle East. Most of Africa is party to it, all of Europe is party to it, all of Latin America is party to it. All but one Central American government is party. Canada's party. Much of the Caribbean and Pacific are parties. And in fact, the 125th state party will shortly be Ukraine. Now, in terms of the litigation before the court, It has been very dynamic. It might not have been as voluminous as one might have thought would be the case, but one must remember that the International Criminal Court only investigates and prosecutes essentially leaders of these atrocity crimes. They don't go to the middle rank, they don't go to the lower rank, the foot soldiers, the ones who actually wield the machetes, fire the guns. That's not what the court looks to. It looks at the leadership level, and leadership crimes are exceptionally difficult to investigate and ultimately bring to prosecution because, of course, one has to get custody of leaders, political leaders, military leaders, business leaders, and that's been very difficult. But I think I'll leave it there for an opening shot and invite Jennifer to sort of fill that out if she'd like to.
Sure, I'll just add on a couple of things. For the audience, if you're maybe less familiar with the field of international justice, going back historically, we've had the Yugoslav Tribunal, the Rwanda Tribunal, Cambodia, Sierra Leone. But at a certain point, it was decided that to keep trying to create different tribunals for different situations was neither efficient, and Ambassador Scheffer certainly knows you have to raise the funds each time, and I know he was involved in those activities. So that was kind of the reason for having the International Criminal Court, one standing institution, rather than creating tribunals ad hoc. And we would like it to have worldwide jurisdiction, but it isn't. So it very much does depend on which states are parties to the statute and the day they became a party, as the court's jurisdiction only goes forward from that date. And in terms of crimes committed on their territory or by their nationals. And the only other way jurisdiction can exist is if the Security Council refers that, but that's only happened a couple of times. So I think I'll leave it with that.
That's great. Well, why don't we dive into the situation at hand? So on November 21st, well, let me back up. Earlier this year, the ICC said that it would like to issue some arrest warrants with regard to the Israeli and Hamas leaders, and there's a process that they need to work through in order to actually be able to do that. So, Jennifer, do you want to just give a brief explanation of how we got to where we are now?
Absolutely. If I could step back a little bit first, maybe just to give the audience some flavor of the kind of work that the ICC does. So it has issued 6 warrants for the situation of Ukraine, 2 for the abduction of Ukrainian children into Russia, and 4 more for the conduct of hostilities. In Uganda, it focused on horrific crimes of the Lord's Resistance Army, and recently prosecuted Dominic Ongwen, one of their leaders. He was convicted for 61 counts of crimes against humanity and war crimes. And that's a conflict that witnessed horrific use of child soldiers. In the Eastern DRC, of course, conflict minerals are fueling horrific fighting and atrocities, and the ICC's had a number of DRC cases. It's trying to bring a Philippines case. There it's focused on the war on drugs, mass executions, drug dealers, drug users, anyone caught up nearby. Think the death toll estimates 12 to 30,000. Myanmar, Bangladesh, of course, we suspect genocide within Myanmar. The court is proceeding. We have a request for the issuance of warrants for some of the leaders there for deportation and persecution. Darfur, horrific crimes of the genocide 2003, 2004. We're now seeing that resurface, and they've recently completed the trial of one Janjaweed, Commander Ali Mohammed Abd al-Rahman. So just to give the audience a flavor of this kind of work, and the court, of course, takes on these cases where the countries are basically unwilling or unable to do them. So there could be complete impunity if we don't have the ICC playing this role. How did we get to the situation regarding Israel-Palestine? The ICC prosecutor issued an application for 5 arrest warrants, 2 Israeli officials, 3 Hamas officials. The court later granted it. 2 of the Hamas officials are confirmed dead. So we're left with 2 warrants on the Israeli side, President Netanyahu and former Israeli Minister of Defense Gallant, and 1 for Hamas commander Mohammed al-Masri. So I do think it's important. We saw the court proceeding on both sides, which is not to say I'm suggesting there's any equivalence of the crimes. In short, the Hamas warrant looks at the crimes of October 7 and alleges a wide number of war crimes and crimes against humanity coming out of the October 7 attacks. And the warrant regarding Israeli officials largely focuses on starvation as a war crime, the intentional infliction of starvation as a method of warfare.
Gotcha. Thank you, Jennifer. Ambassador Scheffer, so perhaps my recollection is erroneous, so certainly correct me here. I do not believe that Israel is a signatory to the Rome Statute. So how is it that the International Criminal Court has jurisdiction over this?
Sure. Well, I think your audience might be interested in knowing that Israel originally did sign the Rome Statute on the same day that the United States signed it, which was December 31st, 2000. And I had the privilege of signing the Rome Statute on behalf of the United States at the direction of President Clinton. And in fact, Israel was there at the UN with me and signed the treaty right after the United States did. Now, a couple of years later, both countries then decided to essentially renege on that signature, although both signatures are still there. It's just that there are little letters and asterisks saying we don't like being a signatory anymore, but the signatures remain. And so that means that Israel is not a state party. The United States is not a state party. So we have no literal obligations towards the International Criminal Court. However, the state of Palestine, if one wishes to use that term, and I know it's controversial to do so, but the state of Palestine, which is recognized by more than about 145 countries around the world, actually recognize the state of Palestine as a state, has become a state party to the Rome Statute as of, what was it, 7 or 8 years ago, or almost 10 years ago. And as a consequence of that, they're also party, by the way, to the Genocide Convention, the state of Palestine. That means that as a state party to the Rome Statute, if a country actually decides to commit war crimes, crimes against humanity, genocide on the territory of the state of Palestine, then you're going to run into some trouble. Because the purpose of the statute, and this was very controversial back in the 1990s, I debated it a lot representing the United States, but the fact is that in the year 2024, I think the law is pretty well established that if you are committing criminal acts on the territory of a nation, then you're going to be subject to the criminal law of that nation. And that criminal law can be influenced or can be governed, shall we say, by a country's treaty relationships. And in this case, the state of Palestine is a state party to the International Criminal Court. And therefore, the fact that the state of Israel is present on the territory of the state of Palestine, allegedly committing war crimes or crimes against humanity, creates the jurisdiction of the International Criminal Court to actually investigate those actions, even though the state of Israel is not a party to the court. Now, interestingly, for October 7th and the actions of Hamas on Israeli territory, again, Israel is not a state party, but Hamas comes from a state party. The Hamas militia are actually shall we say, so-called citizens of the state of Palestine, even though they come from a part of Palestine, Gaza, governed by Hamas. But the International Criminal Court has recognized Gaza as part of the state of Palestine. So that creates the jurisdiction for the prosecutor to say, look, Hamas, if you go on the territory of a non-state party, i.e. Israel, we can charge you for the crimes that you commit in Israel that violate the Rome Statute. So that's what creates this ability of the prosecutor to actually um, uh, investigate and then file applications for arrest warrants against Hamas as well as Israeli officials.
Thanks, Jennifer. Additional
Yeah.
thoughts?
I'll just add on, completely agreeing with David. Yes, we have this division that there are many countries that say Palestine's a state. The US says Palestine's not a state. So the audience might be saying, but how can the ICC treat it as a state? But it actually was very much the UN's decision. So at the UN, Palestine is deemed a non-member observer state. But when they took their instrument of ratification, to the UN as a state, it's the UN that accepted it. So in some way, the ICC is doing no more than reflecting, well, the UN treated them as a state for depository purposes. They could deposit the treaty. And there's actually a pretty narrowly crafted decision because this question of jurisdiction was challenged. And the ICC basically said, well, we are treating them as a party to the Rome Statute because, they followed the steps to deposit the treaty, but we are not ruling on questions of statehood. So they're saying, like,
Exactly.
we leave this to the international community.
Yeah.
We are not getting involved in this.
Yeah.
As a technical matter, the UN took this treaty and treated them as a party to the treaty.
If there's
And I
anything our
really,
audience understands, it is that the law can be very technical and
yeah.
split those fine lines sometimes.
And I do want to emphasize what Jennifer just said, whereas the court did not want to wade into the battle of whether or not the state of Palestine is the state of Palestine. Procedurally, it was following UN actions and then the procedures required to actually become a state party to the Rome Statute.
Ambassador, we had a question on something you said in your sort of intro leading up to this that it feels like now is a good time to ask this question as well. And the question is, why did the United States and Israel back away from their original signatures on the Rome Statute?
Well, I will just say I'm not certain about Israel. At the time, it was Prime Minister Ariel Sharon who made that decision. So one can sort of reflect back to the Sharon administration of Israel and make that determination. For the United States, this occurred under the George W. Bush administration, and I just want to clarify. With respect to the Clinton administration, we want to be very clear about this. President Clinton wanted there to be an international criminal court, and he wanted the United States to be party to it, period. Those were my instructions as ambassador at large for war crimes issues. His instructions to me were make both happen. Make the court happen and make the United States as part of the court happen. So that led, of course, to our signature of the Rome Statute. But then you have to get, the necessary votes in the Senate, the 2/3 vote in the Senate, to ratify a treaty, and that simply wasn't going to occur, given the division within the U.S. Senate. The so-called de-signing occurred in May of 2002, and you have to remember, this was just before major decisions about invading Iraq, which occurred in early 2003. And in my view, the Bush administration was positioning itself to essentially not have, shall we say, sort of the burden of the Rome Statute on their back as they decided to prosecute the so-called war on terror. And I think that was a huge part of the dynamic at the time to literally take that step of de-signing. But it was also because there was a very forceful voice in the George W. Bush administration by the name of John Bolton, who at the time was an Undersecretary of State on arms issues, and he took the lead because he had always been vigorously opposed to the ICC. He took the lead within the Bush administration to basically withdraw the United States from a relationship with the ICC. I will close on this point by simply saying, by the second term of the George W. Bush administration, the sentiment was shifting a bit as to knowing that the ICC actually could be to the benefit of certain American interests. And in fact, it was during that time that very punitive provisions in the American Service Members Protection Act to sort of punish countries that would join the ICC were repealed, because particularly under Secretary of State Condi Rice's leadership, she said, look, we're losing our stake in our interests because these countries are not going to walk away from the ICC, and other countries like Russia and China are going to step into the void with these countries. Why are we shooting ourselves in the foot? And so that sort of opened up the door that was then further opened up during the Obama administration, but then basically shut again under the Trump 1 administration, and then reopened a bit under the Biden administration in terms of our relationship and cooperation with the court.
Gotcha. Thank you. Jennifer, additional thoughts?
Yeah, I'll only add on just in case members of the audience don't realize signing is not what binds a country. So signing is kind of this loose moral commitment. We won't undermine the object and purpose, but it would have to get ratified. So when the US signed, Israel signed, that's not joining the treaty. So the US is not a party to the treaty. I'll only add that.
That pesky Senate approval sometimes makes things more challenging. We have another question in here, and Jennifer, I think I'll start with you first on this one. So that even if you were to consider the Palestinian Authority as a state, how can the fact that any actions in Palestinian territories by Israel or Israeli actors confer jurisdiction over non-state parties acting within those territories?
Yeah.
And if there's whatever the legal basis is for that thinking.
Yeah, so it's how the Rome Statute works of the International Criminal Court. So jurisdiction is created vis-a-vis a country on its territory or vis-a-vis its nationals. So Ukraine recently has deposited its instrument of ratification. Before it had accepted the jurisdiction through another mechanism. But that means Russian crimes on Ukrainian territory are covered. So that is the basis of the ICC arrest warrants for deporting Ukrainian children, horrible crimes in the context of the war. If there's jurisdiction in Ukraine, then it covers Russian crimes when they occur in Ukraine, where at least an element of the crime. The US had been opposed to this approach and said, what do you mean, Afghanistan's a state party. How can you cover US conduct in Afghanistan? And it had been really a sore subject for the US. But it is how the Rome Statute works. That case is not proceeding under the current prosecutor looking at torture by US officials. But this is the basis of jurisdiction. It's on the territory of a state party or by the nationals of the state party, and then Security Council referral. And I think the US original concerns, I believe, have gone out the window when it accepted, Russian crimes are covered on the territory of Ukraine. And there was kind of widespread bipartisan endorsement of this. So I think the US has now kind of moved back from its position. What do you mean about covering non-state parties? It's kind of no more than, if an American commits murder in Paris, well, you can be tried through the French court system. It's the jurisdiction when abroad is not always retained by the original state. There are different ways that jurisdiction is created. So this is how the Rome Statute operates, and that is how they are looking at Myanmar officials. Myanmar is not a state party, but they're looking at crimes where one element spilled over into Bangladesh, which is a state party. So again, they're looking at crimes by Myanmar nationals if an element of crime occurs in Bangladesh. So a number of the court's cases are proceeding on this basis.
Thank you, Jennifer. So I guess for me, the logical next question is what comes next? So with these warrants have been issued for the three remaining surviving of the original five. What are next steps? What will the court do? Ambassador Scheffer, you mentioned originally, or I think it was you, might have been Jennifer. Custody is a challenge, you know. So talk through what will the court do next?
Well, I'll start, and maybe Jennifer will want to chime in as well. The arrest warrants are currently on appeal to the appeals chamber. So the court is not going to, pursue further investigation on these matters or probably insist on enforcement of the arrest warrants until the appeals chamber has examined the arrest warrants against both Mr. Netanyahu and Mr. Gallant. Hard to say how long that will take. Jennifer, you might have gotten a better sense of that at the Assembly of States Parties, how long that appeals process will take. But I think Israel can sort of, in a sense, kind of, I would say sort of relax for the moment in the sense that they are presenting their arguments to the appeals chamber and let the appeals chamber rule on those arguments. I personally think that there was a flaw in the pretrial chamber decision on the arrest warrants. Much of the pretrial decision, I think, was probably correct, but there was one particular flaw in it that I think the appeals chamber will want to look at extremely carefully with respect to how one implements Article 18 under the Rome Statute. I think that's going to be a very rich area of inquiry and scrutiny by the appeals chamber.
David, do you want to pause really quick and explain what Article 18?
Oh, Article 18 states that when the prosecutor launches into an investigation of a situation, he or she will notify the countries that are the targets of the investigation that investigation is intended now to begin. It gives those countries the opportunity to respond and say, wait a minute, we're going to investigate this ourselves. Give us time to do so. And so there's a 6-month window in which the court essentially sort of backs off and lets the domestic court system do its job with respect to the scrutiny of these atrocity crimes and of particular individuals who might be responsible for them. At the end of that 6 months, of course, if the domestic courts, if it's a sham and obviously they're not literally investigating or taking it seriously, then the ICC investigation just plunges ahead. But Article 18 is intended to provide some breathing room. And in my view, the Israel-Hamas war was a significant enough, shall we say, departure from what was occurring in the West Bank in 2021 when the prosecutor gave his first notice to Israel, which was then ignored by Israel, as I understand, essentially. The pretrial chamber decided that 2021 notice was the beginning and end of notification under the Article 18. I just think that common sense and the prosecutor's discretion should have pointed the prosecutor towards a formal notification under Article 18 to Israel, and then give Israel 6 months to actually undertake, investigations if it would choose to do so. So that's sort of where we are with the Israeli arrest warrants. Now, bear in mind, I think it's important to note that these arrest warrants do not charge the crime of genocide. They do not do that. They charge war crimes, as Jennifer said, primarily on the issue of starvation. And I think one needs to be careful to distinguish what the ICC is doing, which is, how do you conduct warfare? How do you do it? Is it in compliance with the law of war? The Israelis would say yes, others would say no. So that's the battle going on with these arrest warrants that are war crimes, crimes against humanity focused. Whereas the International Court of Justice is a state responsibility court, and their genocide is the one and only crime on the table because the state of Palestine, I'm sorry, the state of Israel is a party to the Genocide Convention, as is the state of Palestine, and South Africa is as well, which brought the case along with some other countries. And they're examining genocide, which has a very high threshold of proof and specific intent, and is a somewhat different analysis than what the ICC is doing. So I think it's important to distinguish between those two theaters of activity right now.
Thank you for that. Jennifer, anything you would like to add there?
I think I would only add that first, I have no insight how long this can take. An appeal, we have on the Israel Palestine situation seen a lot of additional interventions from amici, from states, and that can make things take longer. You know, to the extent the question of jurisdiction is again raised, you know, that could be part of it. But even if warrants issue, I want to stress that to the audience, the ICC has no capability of conducting arrests, so it would need to have individuals transferred over to The Hague. So when you do high-level warrants, someone like President Putin, you know, it seems initially very unlikely you're going to have this person transferred to The Hague. There are no trials in absentia at the International Criminal Court. So warrants generally then only act as more of a travel ban because state parties to the Rome Statute are under an obligation to effectuate the arrests. So in the short term, when warrants do issue, and you know, let's say, you know, if the appeal is dismissed or vacated at some point, it would be a more of a travel ban. It would not be, and of course it's to states parties. The US is not a state party. The US also has obligations to allow access to the UN. So, you know, you can't have a restriction on that under the US-UN relationship agreement. So that's kind of what warrants mean.
Got it. Thank you. We have a clarifying question from our audience as well as to whether it is the arrest warrants that are on appeal or is it a jurisdictional challenge to that. So if Ambassador Scheffer, if you wouldn't mind just clearing that up for our audience member.
I had understood it's the arrest warrants because that's the hook to get to the appeals chamber, not just some theoretical argument about jurisdiction. But I mean, I'm happy to be proven wrong on that. Jennifer, I don't know if you've got
No,
a better answer.
I honestly think it was just a clarifying question, and they weren't sure which way. But if I have characterized that incorrectly, I'm sure they will ask a clarifying question of their own. So I shall not worry about that. If the appeal fails and they won't try them in absentia, I'm getting a little bit, I think, into this custody question. Are there, you know, I've seen a lot of editorials and news reports recently about how this might impact the seeming legitimacy of the International Criminal Court and some of the challenges with that. What are your thoughts on that, Jennifer? I'll start with you on that.
Yeah, so the difficulty of, you know, you go high with these high-level warrants and, okay, it looks like the court is taking a strong stance, but your likelihood of apprehension, I think, goes down with the higher level individuals. We still don't have former President Bashir of Sudan, who's wanted on charges of genocide. He's still not in The Hague. So then the court cannot proceed. So I do think it's a balance, and the court should be looking at somewhat, you know, lower down. Now, the court does have the capability of sealed warrants, and these are likely out there. We don't know how many, we don't know which situations, and that's kind of the point of a sealed warrant, that someone might not know that they are under a warrant, and they're more likely than to travel and get apprehended. So I think the court has to balance. High level looks like they're acting, but they need to get people in the docket. They need to be able to have trials. And if they do too many of these where they can't apprehend the individual, then it does start to raise questions. So I'm sure that the court has considered this, and is acting accordingly, trying to proceed in other situations as well, so that they can actually do their cases. So it is a challenge. And as Ambassador Scheffer probably knows much better than I, in the Yugoslav tribunal, there were originally difficulties getting individuals apprehended as well. And it's only when the US conditioned financial aid to countries in the region, and the EU then later conditioned progress in admission to the EU and accession talks, that individuals started to get turned over. So sometimes there really has to be diplomatic leverage and working to get individuals to the ICC. And so far, I don't think I've really seen that from the ICC. Coming back from The Hague recently in the Assembly of State Parties, it's still more discussion of, kind of, Mongolia should have arrested Putin, they didn't. But, we don't really see any real ramifications. So I do think there's some thinking, additional thinking that could be put on trying to make sure more of the warrants get executed.
Can I add, Kristen, to that
Please.
excellent explanation by Jennifer, that I do think we have to realize that there's another element to the arrest warrant story. We often talk about the long arc of international criminal justice. We have to put ourselves almost in the mindset of, once an arrest warrant is out, we may have to wait 10, 15, 20 years before the individual is actually in custody and standing before the court in The Hague. That's just a reality because of the character of these individuals as leaders of countries, where they have the capacity to avoid arrest. But there's another element to all of this, which is, a word that I just think should rise to, like, the word of the year at some point, is the word lustration, which means when you are hit with an international arrest warrant, your legitimacy as a leader, certainly as a world figure, is immediately diminished. Your reputation and your authority domestically may not be immediately challenged. In fact, you may get a bump in popularity because you have been indicted by the ICC. But ultimately, it gnaws away at one's legitimacy. And it just makes it much more difficult to rule in a way that is supportive of, or is supported basically by the large constituency of your population, because you have become an allegedly flawed character. You're an indicted war criminal. You are literally an indicted person that is charged as being a war criminal. So we say you're an indicted war criminal. And that can have an impact. We certainly saw that in the Balkans experience with Milosevic and Karadzic and Mladic, losing their authority because of the indictments against them. Al-Bashir ultimately lost his position of power in Sudan as an indicted war criminal. He's not in The Hague yet, but neither is he in political power. So that is also an impact that can result from these particular arrest warrants.
Yeah, I think I think that arc of justice, the length of that arc sometimes is what is challenging. I'm not sure if it's just from an American perspective, but we're so used to the speedy trial that, thinking that it might take 20 years, and I put speedy in air quotes because we all know they're not always terribly speedy. But to think that some of this might take 20 years in order to actually get custody of someone and bring them to justice just seems like an exceptionally long time to wait. I'm not sure if it's waiting for justice, but for justice to work its way through the system.
And can I just jump in, because you've got Robert Jackson's signature behind you, and of course this is the Jackson Center putting this on, and I've had many such pleasant visits at the Jackson Center over the years. course, Robert Jackson had the immediacy of
Right.
24 Nazi leaders who were in the dock at Nuremberg, 21 ultimately being litigated and
Oh,
or
excellent,
prosecuted.
excellent command of the facts there too,
And
Ambassador. Thank you.
so he had the immediacy of justice, which was fantastic. But you know what? The legacy lives on because it was what happened at Nuremberg that allowed, for example, German courts to prosecute Nazis in their 80s and 90s. So much had been established decades earlier, which ultimately came to fruition with respect to the Third Reich and the crimes of the Third Reich in national courts decades later. And that was the long arc of international criminal justice being wielded by domestic courts. So he laid the foundation at the Nuremberg trials, but my goodness, that just extended for decades.
Yeah. Yeah, absolutely. Just even within Nuremberg itself and the 13 tribunals there, not to mention then as we grow into Tokyo and the ad hoc tribunals in the 90s as well.
Yeah.
All right, a question here. The arrest warrants against Gallant and Netanyahu also charge that crimes against humanity of extermination and persecution. And are those crimes, this is a little bit of a future predicting here, so take that with a grain of salt. Are those crimes on the way to being a charge of genocide? Like they're making the analogy to the former Yugoslavia tribunal. Jennifer, I'll start with you on that one.
Sure. Well, they aren't yet a charge to genocide, and I think it's impossible to know where the court will go. So if they're alleged as crimes against humanity, the context is much easier. Is that, in the context of a widespread or systematic attack pursuant to a state or organizational policy. That's all much easier than the contextual requirements for genocide and the special intent requirement, intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. So that's what makes genocide so difficult to prove. So extermination simply means mass killing, and persecution against a group are much easier to prove in the crime against humanity context. So no idea if the court would expand the charges. So far, it has not leveled genocide charges. And as David mentioned, that is pending at the International Court of Justice. It's a really difficult crime to prevail on in court, which is, I think, why prosecutors often charge crimes against humanity. It's also why the new Crimes Against Humanity Convention is so important to include. It is a much easier charge to prevail on.
Gotcha. Okay. All right. So we have a question that's going to lead me into to another question. So I'm stacking them up here. So the question from our audience is it different this time because Netanyahu is someone who is supported by Western countries? And I want to get into the discussion about the U.S. House of Representatives has passed a bill that would impose sanctions on the ICC, although that hasn't passed the Senate yet. There's been indication that the Senate likely would approve. But what are your thoughts on both the question of, is this complicated because this is a leader that is supported by a variety and number of Western nations? And Jennifer, to your earlier point, some of the custodial issues previously were resolved because the nations were imposing pressure on countries in those regions to make those actions. And then I'll follow that up with a question on what we think about sanctions against the ICC. Ambassador Scheffer, maybe I'll start with you in terms of the complicated question.
Right. Yeah, it's complicated. I mean, the ICC is not immune from the reality of world politics. I mean, it has to operate within a political context, and at the same time pursue the objectivity of its mission, which is when it has properly achieved jurisdiction to investigate and prosecute the crimes within its jurisdiction, the subject matter jurisdiction. I don't think we want to get into a situation necessarily where we are perceived as being essentially duplicitous or hypocritical about looking at well, let's investigate that particular atrocity crime situation, but because of politics, let's not examine another alleged atrocity crime situation. I don't think you have to go there politically or in arguments. Um, but what is important is letting giving the court its ability to exercise its jurisdiction. If you contest its jurisdiction, then do so in the courtroom. I don't think, and I'm going to go straight to your follow-up question, Christian. I think it would be injurious to American interests for there to be a sanctions, bill against the ICC to try to punish the ICC for what has transpired from the prosecutor's office, and which at this time is on appeal to the appeals chamber. The appeals judges may reverse what the prosecutor is seeking to achieve here. What if the appeals chamber does that? Then are you still punishing the ICC for going through the legal procedures of examining these issues, and then ultimately actually pushing back on them? Because at the end of the day, the rule of law is prevailing within the institution itself. I do think that it's injurious to American interests. We've seen this twice, twice before. We saw it in the George W. Bush administration, where there was this huge punitive push with respect to the ICC, which undermined our own interests, backfired on us, and ultimately we withdrew those sanctions because they were backfiring so much. I think it needs to be realized that now almost 125 countries are states party to the Rome Statute. They will not be easily intimidated to back away from what they are supporting, which is the International Criminal Court. And by the way, that doesn't just mean which leaders of those 124 and soon 125 countries think. It's what their own people support. It's what their own constituencies support, and what their own civil societies support. So it's not as if these countries are easy pushovers to simply respond to sanctions, to kind of an argument of oh, it's so meritorious to hit and punch at the ICC. Why don't you join us in doing so? And if you don't join us, then somehow you're outside of the American sphere of interests. That's just not going to fly. I mean, and frankly, within the court itself, I would predict that if there are sanctions imposed on the court, it will only stiffen the spine of judges, of the prosecutor, and certainly of the staff of the court, in terms of doing the job that they're there to do. I don't think it brings any benefit to us whatsoever. Frankly, I think it would backfire. There are arguments that can be made with respect to the ICC. Make them, go for it. Achieve support among other nations for your arguments. But this idea of unilateral sanctions against the ICC, just because it's kind of a political feel-good moment, I think will backfire. It's not in American interests.
Jennifer, you're nodding your head like you have additional thoughts.
Well, I completely endorse everything that David said, and I just to add on in the same direction. The U.S. historically has used sanctions for drug dealers and terrorists. This is a judicial institution. It has prosecutors and judges. Just the use of sanctions against a court to me seems so anathema. And as David has pointed out, it'll be really out of step of so many US allies. Basically, all of the Europeans are parties to the court. And the US would be completely out of step with them. The sanctions, at least the House version, they're completely overbroad. So it would cover anyone who directly engages in, otherwise assists, material assists, sponsors, provides technical support, blah, 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 on behalf of a protected person. And it would cover, it seems to be targeted to prosecutions of non-state parties such as Israel. Maybe it's also aimed at the Philippines, but it's basically going to pick up prosecutor, deputy prosecutor, judges, registrar, etc. It's also going to cover their spouses, their children, their parents, their siblings. And I'm looking at an op-ed Adam Keith wrote, and he explained that many of the ICC staff would be covered. Certainly various of the judges, legal experts. He points out when Belgium gave a €5 million contribution to the Palestine investigations, looks like Belgium could be covered. Human rights groups that provide documentation to the court could be covered. Human rights NGOs that are trying to do advocacy could be covered. Witnesses could be covered. IT services could be covered, and the family members of all of the above. It also leaves me as a US professor wondering if I would be covered if I speak against sanctions or in favor of the court. So it's completely overbroad. And I get it that Congress doesn't like the Netanyahu arrest warrant. I get it. But the problem of these sanctions is they're so overbroad, they're going to harm all of the other investigations. So it's going to harm investigating Russian crimes in Ukraine, crimes in DRC, Uganda, Sudan, CR, Cote d'Ivoire, Philippines, Myanmar, Bangladesh, Venezuela, all of the other situations, because you can't just, oh, we'll try to harm this investigation and not the others. I think they're inadvertently going to be harmful to the entire court, and that means the victims aren't going to see justice, and it's really a disservice to the victims. It's also, I think, embarrassing for the United States. The US has been a leader in so many efforts of international justice, speaking at the Robert H. Jackson Center, obviously a leader in Nuremberg, providing prosecutor Robert H. Jackson to the court, and a leader in the Yugoslav, Rwanda Tribunal, Sierra Leone Special Court, Cambodia, all the tribunals David has worked with. So to try to undermine the court is then kind of turning our back on all of this precedent. And I do think it will backfire against the US. David has referred to the last time the US tried to bully, or what the first time the US was bullying the court, and it threw countries into China's sphere of influence. It really backfired to pressure countries to sign agreements. They'll never turn an American over to The Hague or risk losing US financial support. Well, some of them said, okay, we'll decline US financial support, and they got it from China. So it completely backfired. So, you know, I'm not arguing the US needs to join the ICC. I hope they do someday, but they don't need to do so. That right now, that is a US decision. The US would have no legal obligation to comply with ICC arrest warrants. The US is not a state party. They don't have to. And, you know, the US doesn't need to support that investigation. The US has chosen, we're going to support the Ukraine-Russia investigation. The US has that choice. Yeah, I think to sum it up, a judicial institution needs to be left alone to do its work. And as David has said, you know, opposition should confine itself to legal arguments.
A quick follow-up question from our audience as well, and that is, what if sanctions are imposed via executive order rather than working its way through the House and Senate process? Are there legal arguments that could be raised against such an order, and what might those be, and their likelihood of success?
Jennifer, do you want to take that? Why don't you take that first? Yeah.
Okay, thanks, Larry, for that question. Yeah, unfortunately, so we talked about Congress passing sanctions, and they could just be implemented by executive order. So it's hard to tell what kind of challenge could be brought because we don't see the text. So if it follows the House text, I think that's completely overbroad, and potentially challenging free speech. We don't know what text an executive order would take. So we would need to see the text. So those are two things to look for: overbreadth, free speech challenges. And such litigation was brought the last time sanctions were imposed by under the prior Trump administration, and both the Open Society Justice Initiative and the ACLU brought cases, and I think they were able to challenge, I think, overbreadth, and I'm guessing free speech, but I would think those would be the typical arguments. It's harder, if one reaches national security, if that is invoked, because of course, give such deference to kind of State Department briefs if they're going to invoke that. So that could be a more difficult path. So I would think challenges can be brought. In the interval, the sanctions are in place. I think our best bet, if it's at all possible, is to head off the sanctions, if that could possibly be done. And, I am pleased to say that the American branch of the ILA, and I can't claim credit because it was the ICC committee, I'm sorry, IHL committee who issued this, not the ICC committee that I co-chair, has issued an excellent statement. Oh, I can't share it, Kristen.
I was gonna say, if you put it in our chat, I can add it into
the chat. Okay.
Yes.
Okay, I will. So I'm just going to share that link for anyone who wants to look at an excellent statement, I think, opposed to sanctions.
By the way, I think if my memory serves me correct, and it may not, under the first Trump administration, the sanctions were by executive order. I seem to recall that. So it is possible that could happen quite soon by executive order.
That's great. Okay. I want to be respectful of your time. There is one question that's a little bit broader, but I think is an interesting question. So if you will indulge me for a moment, a question from our audience about sort of the interplay between Article 27 and Article 98 in terms of has the decision of the International Criminal Court that under customary international law, heads of state do not enjoy immunity under international criminal law, rendered Article 98 obsolete?
No, that's not correct. And I think I can say so because I spent a lot of time drafting Article 98. Article 27 is one of the most important provisions, frankly, in international criminal law that we've seen in a long time, which is that it removes head of state immunity from those officials of states parties who might be charged with atrocity crimes under the Rome Statute. They cannot exercise their head of state immunity. Why? Because their country is a state party to the Rome Statute. So even the French had to amend their constitution in order to ratify the Rome Statute and remove that head of state immunity if the context is the Rome Statute and the atrocity crimes under the Rome Statute that are being prosecuted. Article 98, I think, has been misinterpreted in many ways, and the court has spoken to this very, very directly with respect to kind of a series of cases, including the al-Bashir case, where countries, for example, Jordan, allowed al-Bashir of Sudan to land on their territory as an indicted war criminal and not arrest him. And the argument that Jordan made was, oh, well, Article 98.1 permits us to, recognize his head of state immunity. And what the court clarified in its decisions on this is twofold. First, this is not a decision for the state to make. This is strictly if the court wants to make a decision about head of state immunity, it's the court that takes the initiative to make that determination. It's not the state stepping forward and invoking head of state immunity for some visiting indicted war criminal and saying, we don't have to arrest him. No, actually, you have to arrest him. And then if the court wants to determine that somehow he has head of state immunity, fine. That's up to the court to make that decision. It's not for you as a government to unilaterally decide that when the indicted war criminal lands on your territory as a state party, because as a state party, you're obligated to arrest him. But the other thing is that the court made it very, very clear that customary international law has gravitated to the level, including with the support of the International Court of Justice, that if you are indicted and being pursued by an international criminal court, underline the word international, then customary international law has gravitated to the level that you no longer enjoy head of state immunity with respect to an international criminal court. If it's a regional court or a domestic court, go for it. You know, claim your head of state immunity, romp around the world. But if it's an international one, then the law has evolved. And that's basically what the ICC has ruled quite definitively.
Thank you for that. All right. Well, I would very much like to thank Professor Jennifer Trahan and Ambassador David Scheffer for sharing their thoughts with all of us today. And thank you to our audience for joining this discussion on the International Criminal Court arrest warrants. I hope we have provided some food for thought and some information that was new to you. Hopefully you all know that all of our programs are free and open to the public because we believe access to the best information makes all of us better. And so if you are interested in supporting the Robert H. Jackson Center or any of our programs, please go to roberthjackson.org/donate. And you can access any of our programs on our YouTube channel. While you're there, please subscribe. And Professor Trahan, Ambassador Scheffer, thank you so very much for contributing your thoughts today. We deeply appreciate it.
Thank you.
Thank you. Enjoyed it.
Thank you, everyone.